I mean, the parties know when they enter into an adjudication that it should be a rough and ready process. So that is exactly why most of these rules say when you give your referral, you need to give all your documents, all your information that you want to rely on. And you have a limited time to supplement that. So I think a lot of responsibility lies on the adjudicator to properly manage the process in such a way that they are comfortable they've got sufficient details of the matter to make a decision.
Thanks, Lize-Mere. It might be interesting to hear from Damian on this particular point in light of his experience in the UK, where it seems things are done a lot quicker than they are here. Damian, any words of wisdom on this?
Difficult to give words of wisdom because adjudication still sort of remains as a lottery. However, I think the starting point is the quality of the submission. How the referral is framed so that the adjudicator instantly understands. And I think the fundamental issue for me is to make the adjudicator's job as simple as possible. Let them know what you are talking about, direct them to the documents in terms of what you rely upon, and make that process work within the time frame of the 28 days or the 42 days. And yes, in the UK, we do also extend them beyond 42 days for complex matters, but the same parameters work. It's keeping the referral documents and any further documents as simple as possible, making the adjudicator's job easy. If you make the adjudicator's job difficult, then you will get an adverse decision or you won't get the decision that you want. So I'm going to talk to that a little bit more, Stephanie, but hopefully that helps.
Yeah, that's great. Thanks, Damian. Okay, I think we've covered a number of questions and comments from the participants. Let's move on to Damian, who's going to talk about money.
Thanks, Stephanie. It's a topic I always like to talk about, money. So, but firstly, thanks to Deanna and Lize-Mere for your excellent presentations, and obviously, Stephanie, your moderation skills are exceptional. So, thank you very much. It's always difficult going last, as most of the good things have been said. So, I may repeat one or two things, but I'll try to avoid them as best I can. For those who don't know me, I'm Damian James. I'm a chartered surveyor practicing as an expert in delay and quantum on an international basis, and I am an adjudicator in the UK. The domestic arbitration market in the UK is minimal. We do have domestic arbitrations, but we don't have a great deal. And adjudication leads the dispute resolution process. The UK adjudication process is a quick process. It's aimed at facilitating cash flow and often takes place within 28 or 42 days. We heard Michaeli say there that the underlying principle of adjudication is rough and ready justice, or pay now and argue later. And he is correct, but the other purpose is to move the cash and allow construction projects to progress without progressing to arbitration, which was our default position in the 70s and 80s in the UK. And all you had to do was put up a defence to a claim, which meant you're either in arbitration or you're in litigation. And that was before Latham became involved. When Latham became involved, it was about making sure that we could sustain an industry and keep an industry moving and not necessarily pay people claims which are not correct, etc., but avoid the insolvencies, the big issues that arise. And we had unions coming on board then to protect their employees and their workers, because contractors and employers would basically hit a wall and not work with each other any further. Tiffany, I'm starting at slide 10, I think. And I think in my presentation or my discussion, so to speak, I want to deal with more of the nuts and bolts and our adjudicators' progress to a decision, which obviously includes the scope of what the adjudicator can decide, but specifically from the perspective of the relief sought. So in simple terms, the adjudicator is going to decide the matters in the dispute. In order to do that, she must determine the scope of the dispute. So I now talk to you in respect to the quantum perspective and what that entails. And what I want to touch on is how enormous these things can become and how we have to contain them, manage them, and how the parties are actually responsible for so much of the work in the adjudication. So the notice of adjudication, the documents referred to in the notice of adjudication, the defences raised by the responding party, which we are yet to see, and new issues expressly or implicitly introduced during the adjudication define the scope. So in my experience, the adjudicator may also take account of matters arising under the dispute, which are connected with the dispute. So we're just seeing a growth in documents all the time here, which is obviously a big concern for adjudicators with complex disputes, as we've just talked to. There's not necessarily an obligation on our adjudicator to look at anything which is connected with the dispute, but she may do, and she may think it's appropriate, definitely in the circumstances of what we have before us. So in simple terms, it may be that matters that are connected with the dispute referred to adjudication are necessary for her to determine so that she can decide the original dispute referred to her. And I talk about that specifically in terms of quantum. So where are we with this referral notice in this mock adjudication that we have running? Well, we assume that the referral and any notice that applied before address the same issues. So we rely on what we have in the referral, setting down the scope. What else does the referral include? And what else does it expressly or intrinsically imply? Well, it seems to do quite a lot of that in my mind. At this stage, though, without the reply, our adjudicator is not necessarily able to define the issues and any surrounding documents completely. But the issue that does arise is the engineer's determination, and that document and what it was based on are all available in the appendices. Notwithstanding the contractual aspects of the determination, where is our adjudicator with the dispute process? So Tiffany, perhaps if we can just raise the first poll. And the question, which has probably been answered really by Lize-Mere and Diana. I'll just wait for Tiffany. Can our adjudicator decide that any decision or determination given by any person referred to in the contract may be A, opened up, B, revised, and C, reviewed by the adjudicator, or D, all of the above?
Okay, I'm going to share the results.
Well, thankfully, with all the eminent people in the room, including 3 lawyers that I'm working with here, D, all of the above is the answer that I suggested it was. So thankfully, I've been confirmed by my colleagues and everybody in the room. So thank you very much. I asked that question specifically because in the UK, statutory provisions of the scheme would provide for a certificate for payment due to the statutory right to interim payment. So in the UK, you'll find that an adjudicator can produce a certificate if one's not being produced. There doesn't need to be a certificate in play. If there is no certificate, then the adjudicator can provide one. Obviously, we're in a contractual adjudication in South Africa. So maybe we reconsider the question, and you can put the second poll up, please, Tiffany. And that question is, does the adjudicator have jurisdiction to provide her own determination when a determination has already been issued? A, jurisdiction is limited when a determination has been issued. B, jurisdiction is not limited. C, the adjudicator can issue a determination herself. Or D, the adjudicator could provide her own determination if this has been specifically referred. I'll just give you a second to consider that.
The results, Damian.
Thank you, Tiffany. Quite a spread there with the exception of B. The answer was actually D in the context of this matter. So congratulations to those who came up with D. I did wonder whether between those 2 questions people might change their minds, but maybe if we just pause on that, on what grounds should our adjudicator look past the engineer's determination and open it up? We have a referring party who wants that to be done. Is it simply because she's been asked to do? I think in this circumstance, our adjudicator can look at the determination because that is what the referral asks for. If our adjudicator then decides that she has the right to open up the determination, then what must be considered next? Well, there's a whole wave of documents coming here. I would suggest that the first thing to consider if I was adjudicated in this matter is the date for my decision, given the extensive information coming her way. Can she effectively address the volume of information within the determination, within the time period afforded to her? Can she provide a clear, concise and cogent decision within the timescale? Clear, concise and cogent is the 3C mantra that Pickavance advocates in his adjudication book, which is available across the world. So Tiffany, can we take a quick poll just on whether the adjudicator can request more time from the parties?
Here we go.
Okay. Well, it seems that people elected mostly for A and D. The answer that I saw there was C and D. So it may differ slightly for those of you who chose A. And that's partly because the rules will set down the process in respect of the period of time, etc. But the parties are obviously free to agree whichever periods they want. Purpose there is obviously to ensure that the adjudicator arrives at a decision within the right period of time. Now, obviously in statutory adjudications, we have 28 days, which is extended to 42 days, but that can only be extended by way of the referring party agreeing to such because it's their claim. So our adjudicator now decides to review the determination, then what next? Well, in simple terms, and I've seen this in adjudications, there's a possibility that she finds that the submissions of the claimant were woefully poor and the engineer could do nothing more than determine it as 0. There may be issues in the referral that contradict the relief sought, and we've heard about that extensively today in terms of the acceleration issues. Importantly, the adjudicator is not there to correct errors in submissions. She may decide that she need not look any further than the engineer's determination, and may say that the engineer's determination is a good determination of the claim, and not have to look at all this information. And or she may say the referring party failed to demonstrate any adequate cause and effect. Now, we heard Lize-Mere talk about that in respect of how you demonstrate acceleration, which is a whole nother lecture and webinar. Often the return of those types of comments are taught to fail to demonstrate adequate cause and effect, and the engineer's determination is a good determination, may be damaging to a referring party's ultimate position in an ongoing dispute. However, our referring party states at paragraph 34.3, the engineer did not make a fair determination as required under clause 3.5 of the contract. And then again at paragraph 35, the engineer's determination should therefore be opened up and revised by the adjudicator. So be revised by the adjudicator. We have a series of appendices within the submission that it's necessary for the adjudicator to review. So we can see that in this first submission, in this referral submission, which is the key document here for the claiming party, Appendix A includes the contract documents. And we don't know what these extend to, but they may extend to thousands of pages. B and C include the notices, which seems appropriate. D refers to the letter, which is taught to in the determination. E provides the engineer's determination, which includes a further 2 appendices, which obviously then need to be reviewed as well. Importantly, appendices I and J provide cost details, which at the moment are unseen, but these could extend to thousands of pages and include multiple calculations. Tiffany, maybe we can move to the next slide, please. And maybe we can firstly talk to the contract, which obviously is the most fundamental document in play here, because we know with FIDIC, and the FIDIC has obviously been revised over the last 4 or 5 years to the 2017, with the purpose of being more user-friendly and avoiding disputes. But obviously, we're talking to a 1999 version here. And we talk about the fully detailed claim. So those of you who are FIDIC practitioners will know about the steps you have to take to arrive at a fully detailed claim. How you prepare it, the detailed description, the contractual and the legal basis, the contemporary records, the supporting particulars, the submission of the fully detailed claim, the hurdles you have to overcome in respect to the time bars for the claimant party, the time limit for the engineer, the additional particulars, whether they're reasonably requested by the engineer, and then obviously the ultimate situation, which is the agreement, or in this case, the determination of the claim. So when you look at those parts of the detailed claim, what do they talk to? Well, they talk to detailed description of the events or circumstances giving rise to the claim. That should be fairly straightforward. A statement of the contractual and or other legal basis of the claim. Well, this needs to go in right at the start of the process and obviously needs to be reiterated in this referral. And importantly, we also talk to all the contemporary records on which the claiming party relies. Now, we've heard Lize-Mere talk about acceleration and contemporaneous records. This is the essence of the records that we require in order to prove our case. And also detailed supporting particulars of the amount of additional payment claimed or extension of time. So already we're in a situation where the adjudicator has a great bundle of documents to consider and lots of issues to consider, and almost place herself back in the position of the engineer at the time of this determination. So if the initial submission wasn't good enough for the engineer to determine, then where does the adjudicator go with this? The adjudicator has to say that the engineer erred in his approach and determined it incorrectly. That's what they asked for in the referral. But the engineer most likely would have acted on the basis that this was the documents that were supported to it. So those documents aren't necessarily going to change. It's just the opinion or the determination of the documents as presented. So we look at detailed description, we look at contractual and legal basis, we look at contemporary records. And what does that mean? Well, that means the records that are prepared or generated at the same time or immediately after the event or circumstance giving rise to the claim. We know that the engineer has an opportunity in the whole FIDIC process to monitor the contractor's contemporaneous records, so that should assist the referring party. We also know that the contractor can keep additional records, and we also know that the engineer can inspect those contemporary records, and those are practices that they ought to enter into during the process of the contract. Supporting particulars, well, we'll always find ourselves in a particular situation. We used to find ourselves in a situation back in the late 80s, early 90s in the UK in terms of the JCT contract, where we will constantly ask for more particulars, and that the architect who used to determine claims at that point in time couldn't see any further with the documents that he has and required more and more information. At some point that becomes disproportionate to the whole matter. So detailed claim, period in which the claiming party must submit. And we talked to the double time bar there in terms of the FIDIC contract. I'm not going to talk about that today. Additional particulars, determination of the claim, that deals with additional payment and it deals with the extension of time. So having reviewed all the requirements in the determination, our adjudicator has a lot to do in a short space of time to conclude differently from the engineer who states at paragraph 21, 8.1 in the documents you have. The alleged instruction to accelerate, if any, is firstly unproven, and secondly, if the alleged instruction had been furnished to the contractor as alleged, is not a valid instruction in terms of the provisions of the contract. So there's an issue there for our adjudicator. If we then turn to costs and records and entitlement, then what is the adjudicator expecting to see? Well, again, the engineer states at paragraph 21.10, the contractor has failed to demonstrate acceleration of the works on any basis. The general rules of evidence in adjudication tend to apply. Adjudicating parties should aim to set out their case to the adjudicator as clearly and succinctly as possible. I think in certain cases, just providing the same documents you've had before and giving to someone else to give a second opinion may not be the essence of an adjudication. Too much material can obscure the real issues. We must make this simple and it needs to be balanced. Complex issues require technical and expert evidence and mostly records. In broad terms, the adjudicator in this scenario must find the essential ingredient for analysis, evidence of causation. Well, what is that? The acceleration as alleged. We heard from Lize-Mere, and she mentioned the concept of constructive acceleration, which in my experience is met with lots and lots of challenges in most jurisdictions. The only place that I've ever worked with constructive acceleration where it seems to be an accepted principle is the USA. If you recall, Nicholas asked, can a contractor refuse to accelerate, which opened up a second debate on the contract terms. And Michelle talked to the prudent contractor's election to accept LADs, which may well be the case. It may be the best thing to do. I also saw that Andrew mentioned multiplex at Wembley. And thanks for mentioning that. That brought back some bad memories for me, Andrew. It was a project that aged me very quickly. In broad terms, though, there must be a sufficient connection between the breach and the loss in order to recover damages for the breach of a contract. The damage suffered must be caused by the breach of contract. We know that as practitioners, and we know that it's called causation. We require records of the effects. Those records are extensive, and they may include such items as correspondence, progress reports, updated programs, critical path analysis. We have program in play here. We have a progress situation which is delayed. There's an allegation that it's one party's fault. There's an allegation that the party has to speed up. There's an allegation that they speed up purposely because they are instructed to do so. We also have a converse argument which says you speed it up to recover your own delay. The adjudicator here needs to look at the programs, needs to look at critical path analysis. We've touched on support from experts, etc., but this is the referring party's case. We also then extend to timesheets, purchase orders, invoices, labour payments, proof of payments, and account statements. We've all been through the process of proving burn rates and cost rates and the extent that we must go to in order to determine those correctly. If our adjudicator can traverse her way through this aspect, then what are the questions for our adjudicator and analysis? Has the party incurred the sums that it claims? Can she disseminate this from the documents that are in play? Should appendixes I and J evidence this? Do they evidence it? Well, the question involves detailed evaluation of the contractor's claim as it was presented, whether the sums claimed are verifiable through various stages of the contractor's claim, and whether those costs can be traced back to the contractor's cost and accounting system for the project, whether the sums claimed are estimates or forecasts, or whether they're actual costs. Has the contractor taken into account credits, transfers, discounts, all those usual situations that we talked to? Importantly, to verify that such cost claims have been incurred, is access to documents which identify the claims made and are compatible with the cost and accounting system for the project necessary to be provided? Should the referring party have provided those? Is that where the adjudicator looks in respect to that cost having been evidenced as having been incurred? There's lots of places we can go to this in terms of tender build-ups of how the contractor planned to do the work, why he finds himself in this delay situation, and why that claim should be seen as being a good claim on the contractor's behalf. Again, the documentation identifying total cost of the project to the contractor, including all of its subcontractors, would have to be presented to demonstrate that, and you have to show that the cost has been incurred. Maybe ask yourself whether that's going too far. An explanation of the contractor's accounting system, how records are documented into there, which shows sufficient detail to allow the adjudicator, even if they were to sample, to track invoices, payment vouchers, certificates, bank statements, cost ledgers, job costing systems, cost allocation, to understand that these costs have actually been or are likely to be incurred. That's what our adjudicator is looking for. Proper allocation of the cost of the project and the matters complained of has been made. Well, we look at that in respect of ensuring that costs are allocated correctly in the right project. If you find one which is incorrectly allocated, then it may be damaging to the whole situation. Has our adjudicator the time to do all this? Well, in the ambit of the referral, it suggests that she must. We talk about the correspondence, the final accounts, records of subcontractors and suppliers and separate contracts, anything which is allied to the allegation of the additional costs as they arise. Contractors' internal reconciliation statements, copies of subcontract supplier contracts, copies of all claims, counterclaims, contra charges against other parties. Maybe the subcontractors have paid for this delay, who knows? And generally details and substantiation which are advanced within the claim and how they're supported. In respect of site records, these extend, but they're not limited to, and site records ought to be getting better in a digital world, but sometimes I think they're actually getting worse, but they should extend to diaries. Sometimes it's actually nice to see somebody who's written something down in a diary and records what's happened on a certain day with some alacrity. Photographs, cross-referenced, and allocation sheets. And then importantly, the extent to which the sums that the contractor claims are attributable to the matters relied on by the contractor. And that's where we talk, as Lize-Mere talked to, the nexus between the instruction and the cost arising. If we allege one thing, and this is the causation, then the effect needs to be linked by way of the nexus. And that involves a detailed evaluation of the contractor's claim. Have the sums been correctly allocated to the project? Are the sums claimed one-off? The reasons, the matters, the events which it alleges to have given rise to the sums claimed. Whether the sums claims would have been incurred in any event. It may be that the contractor might have spent this money anyway, but now it tries to convert them to an acceleration claim. We talk about the consideration of what was included in the tender build-ups and how the contractor planned to do things. These are all issues that the adjudicator is going to ask themselves, but will only consider in respect to the evidence that's before them. At the moment, we have a determination and a referral, and the referral includes appendixes I and J, and those are the two documents that I'm interested in. Again, there's a further question, which is obviously whether costs are reasonable. And that tends to be forgotten by lots of people in terms of disputes and claims that are put forward. It's not appropriate to throw the kitchen sink at costs in that respect and try to recover everything. So the costs need to be reasonable. They need to be appropriate for what was being carried out. They need to have regard to the circumstances prevailing and when the work was carried out. And importantly, the adjudicator will want to understand that that is correct in making any decision in respect to those costs. And that comes back yet again to the referring party's submissions. What did the engineer talk to in this? Well, the engineer stated at paragraph 21 through 21.1 to 21.1.5, he talked of employment contracts of the alleged additional personnel. So he's talking about the same thing I'm expecting to see. He talked about daily diaries reflecting the overtime spent on the project, because that is the allegation. There was more time. You all answered the same question in respect of the chat box in that respect. Pay slips reflecting payments made to the alleged additional personnel. I've worked on these matters myself within South Africa, and that can be a very taxing task to take on when you have multiple workers over long periods. So if you have 1,000 men working over 8 weeks, you have 8,000 records to deal with in that respect, which is cross-referenced, have to be dealt with in respect of what's the cost to company, the UIF, etc. How do you make that simple to the adjudicator in these circumstances? Training attendance registers for the relevant personnel and invoices for each of the costs incurred. Well, maybe I would go further than that. I would want to see invoices for each of the costs incurred and proof that that's been paid. However, as a general rule, there's no strict criterion as to the format or type of evidence which must be provided in adjudication. As I said earlier, it's about making the adjudicator's job and role as easy as possible. Although adjudications are governed by particular conditions within certain contracts, the production of evidence within the FID, it does help in that respect, and I'm sure that that is something the adjudicator has to consider here. Adjudicating parties should aim to set out their case to the adjudicator as clearly and succinctly as possible. Too much material can obscure the real issues, but this needs to be balanced, and that's why you should see cross-referencing between documents so that you understand the causation, the nexus to the effect, and the adjudicator can see where those costs are. What needs to be considered here by the adjudicator is stated in the referral, and it says at 14.1, the determination by the engineer is incorrect. On what basis is it incorrect? The instruction to the contractor to accelerate the works constitutes a variation under clause 13 of the contract. The contractor is entitled to additional costs in the amount of £5 million, just over £5 million. At 14.4, the contractor is entitled to additional costs in the amount of £598,000 pursuant to additional work done at specific instance. So these are big numbers, they're not small numbers, but they are necessarily evidenced by a great deal of records. So if too little material is contained within the referral, the result may be that there's an unsatisfactory drip feed of further information, which disrupts the adjudication process, and that in itself causes this adjudication process to go longer. In this matter, costs are supported by appendices I and J, we know that, and this will form the basis of the adjudicator's review of the monetary entitlement. Do the referring party get a second chance to support this with more information because the adjudicator can't find a way through? I would suggest that that might be an issue, and it's the context and the content of the first documents, the referral documents, which simplify the process for our adjudicator here. We talk about cross-referencing documents within the referral, make the party's case cleaner, simple, and allow the adjudicator to follow. Failure to produce adequate documents, well, that may lead the adjudicator to making adverse inferences. So it's imperative that referral notice and when the response comes is carefully considered and the appropriate evidence is submitted to make the adjudicator's job easier. Witnesses are not a requirement in the adjudication proceedings, and in small disputes they should be avoided. But remember, adjudication is designed to be quick and cost effective. Go back to Michaela's point, only use witnesses if you absolutely have to. In the following circumstances, it may be considered that witness statements are appropriate, and that might be a situation where there's an important dispute of fact between the parties. For example, an agreement made verbally between the parties, as is the case here, or a particular instruction that is carried out. Again, the case here. If the evidence is likely to be contentious, maybe that is the case here, we've not heard from the responding party yet, the adjudicator is likely to give it more weight if it's included in a witness statement with a statement of truth, rather than just an signed letter that we seem to have in play. In a large dispute, appending witness statements can be useful, and that's when we talk to the complex ones, because it produces the detail required without overburdening the referral notice, and that helps with obviously within the timescales. I will say that in this matter, we do not have witness statements from the referring party that I can see. Just as a side, and obviously war stories are all part of the role as a construction professional, and trying to relay issues to people. In a recent adjudication, and I'm talking within the last 28-day period, I acted for the responding party. I acted for the referring party. And in the response, the responding party submitted witness statements, and the adjudicator did not allow response by the referring party. He stated, in my initial directions, number 1, in the letter dated the 2nd of February 2022, I advised the parties should ensure that the referral and the response contain all relevant contentions and the supporting documentation and evidence on which they rely. He went further and said, in compliance with my directions, the responding party has chosen to provide witness statements to support its contentions. The exhibits referred to in the witness statements are documents that have already been exchanged between the parties. Now, from the referring party's point of view, there's a question of natural justice raised here in terms of not allowing the referring party to respond to allegations of a factual nature. It's not been taken further because the result of the adjudication wasn't destructive to either party's situation, but it'll move, and the matter will be allowed to move forward. It's helped the parties in terms of the adjudication process that they both know their case, they both know their strengths, they both actually know where the issues are crystallised, and the parties are now trying to talk and resolve it. But I think it's important that when I talk to that, I say the adjudicator was clear. The parties should ensure that the referral and the response contain all relevant contentions and the supporting documentation and evidence on which they rely. The adjudicator says that because he wants to deal with it within the timescale, and in dealing with it at the timescale, he doesn't allow the drip feed to run from there, and that whole process of adjudications all almost becoming mini arbitrations. Again, we talked about expert evidence, and it is required to support a party's case, then it should be enclosed in the referral. In this matter, we don't have any expert evidence that I can see at this point in time. So in summary, before I hand back to Stephanie and the questions that are that need to be taken, evidence in adjudication proceedings is becoming increasingly common as the process is used for more complex disputes. And I'd take you back to that same point. It's the referral and response contain all relevant contentions. If you want to support your costs, then you must provide the costs. Appendix I and J are the supporting documents to the cost in this matter. The type and quality of the information is essential. It avoids the long periods, it avoids the escalating costs, it avoids the litigious challenges to the adjudicator's decision, and ensures that you have a clear grasp of procedures. Applying that process and submitting evidence in adjudication proceedings makes the adjudicator's job easier. I think in terms of this process and this mentoring process here, you have to consider whether the adjudicator's job has been made easier. So my considerations in this respect are simply that: has the adjudicator's job been made easy by the referral? The documents that I talked to in terms of quantification and analysis, and we talked to delay, we talked to critical path, we talked to acceleration. There's a whole myriad of different things in there which need to be dealt with. Has that been accurately or adequately and sufficiently explained within the referral? Look at it in the alternative. Has the responding party's job been made easier by the referring party? Does the adjudicator need expert assistance? And then on my final note, maybe Tiffany, we can move to the final slide and my final poll, which is a question that I like to ask of people in respect of adjudication. And I ask this question partly because of the context of this adjudication, partly because of the context of my discussion there in respect of all the documents I've talked to, the quantification, the issues that arise in there. We have issues of delay, we have issues of quantity surveying, we have issues of audit control, we have contractual issues, we have legal issues, we have procedural issues. Should the referring party have requested a construction professional who is qualified in adjudication to undertake this adjudication? Now, I ask that question because obviously one of the precursors on the RICS adjudication nomination pages, and TechSAR and TechBar, which are the other two dominant nominating bodies in the UK with the CIARB, they will specifically ask which type of adjudicator do you need, and they talk to the conflicts. So maybe we can just give that some thought process and we'll see what results we get.
Here we go, Damian.
Thanks, Tiffany. Well, the answers are split really between A and C. And I'm glad to see A, because I'm a non-lawyer acting as a construction professional in adjudication. But I think my answer was C to this. It doesn't matter, a qualified and experienced adjudicator can manage the process and they will be able to deal with lots and lots of these issues. But as we've heard already, it's a inquisitorial approach to dispute resolution. The adjudicator can take the initiative, and maybe certain professionals are more suited to that than others. But that concludes that question, or that poll actually concludes my presentation. I hope you found it enjoyable. I'll hand back to you, Stephanie, for the close.